would be greatly improved if Clause 4 were deleted.
Speak to Amendment 21, standing in my name. It dawned on me, and I said in committee, that the purpose of some noble lords was not to improve this legislation that has been passed by the Commons, but to eviscerate it. And the speech just given by the noble Lord Grosvenor seems to me to illustrate exactly that. Now, the noble Lord, one of the few things I agreed with in committee with my noble friend Lord Willits was when he said that there were two powerful elements in this bill that made a real change, and one of them was Clause 4. That's why I think it's a crying shame that the government has conceded so much in relation to Clause 4 and has effectively turned it into a shriveled sausage when it could have been something that actually made a real difference. But it doesn't seem, even then, with that concession from the front bench, to be enough for my noble friend Lord Willits, or indeed for the noble Lord Grosvenor, who are insisting that even that pathetic thing is removed and crushed altogether. Now, a principal argument in favour of the proposal, in favour of Amendment 20 from my noble friends on the front bench, is that they intend thereby to give the universities an opportunity to resolve the problem through mediation and through a complaint system. The difficulty is, my lords, that in terms, university authorities have expressed repeatedly the fact that they do not consider that there is a problem, that they consider it to be an invented problem, or a problem which, if it exists, at all, is rare and egregious and can be handled by the universities, when plainly there are those of us who feel that the universities have failed to handle it and need to be brought to book. If the universities genuinely want to give mediation a chance, then the amendment number 21 standing in my name gives them the opportunity to demonstrate that. It was tabled at committee by the noble Lord, my noble friend Lord Sandhurst, and is retabled here, and I'm grateful to the noble Baroness Lady Fox of Buckley and the noble Lord Strathcarron, my noble friend Lord Strathcarron, for adding their names to it. Amendment 21 would retain the substance of Clause 4 as originally proposed by the Commons and approved by the other, originally proposed by the government and approved by the other place, but would give to the university the opportunity in each case to ask the court to stay proceedings so as to allow mediation to take place. And it would be at the discretion of the court whether to agree to that. I'm sure if they thought there was a prospect of success in the mediations, the court would agree. This is modelled on legal practice in certain other areas. The provision exists, the possibility exists. For example, I understand, and noble lords know I make no claim to be a legal expert, in relation to pensions, entitlements, and so forth. So the principle is a workable one. The university can say, please will you stay the proceedings while we exercise mediation. But it preserves the substance of the tort in Clause 4 and gives academics particularly an opportunity to make their representations in the way that the government originally envisaged. The government's proposal, and it's the government's proposal I'm addressing because, of course, the proposal being advanced by the noble Lord Willits, I understand, may speak shortly, and endorsed by the noble Lord Grosvenor, is to delete the clause altogether. But the government's proposal would allow those administering the complaint system to indulge in indefinite delay. There is no time limit by which a decision has to be reached in this amendment. My noble friend Earl Howe said that something vague about how he thought 12 months might be something that already exists and might therefore be applied or extended to this activity. But there is actually no time limit by which a complaint has to be resolved, which would allow the complainant to trigger the tort. It would remove the possibility of seeking urgent injunctive relief, which is something that could be obtained through the courts. And it would push complainants back to effectively a choice between a financially ruinous application for judicial review, because that is what it is financially ruinous for the individual, or continuing with a possibly endless complaints process in which, as has been said by others in this context, the punishment is the process. So you're an academic, you have a career to pursue, you're probably not even on a properly tenured post, and in order to vindicate your rights, you have to undertake a process extending potentially over many months, which comes to consume your life and ultimately to damage your career. It is an unenviable choice, and the tort gave people some other option to allow potentially for more rapid relief. But most of all, the government's amendment sends a signal. It sends a signal to academics who feel oppressed, who feel they cannot express themselves, who feel that they are required to conform to an ideology which they know in their heart they do not endorse. That a government which had said it was on their side and was taking steps in order to protect them is no longer interested. And that is a very bad signal indeed to be sending. I'm sorry to say this, but I do think the government is being feeble. Now, it might be nice, to conclude, if the front bench, having shown itself, now that was a heckle of some value, it might be nice, in order to conclude, if the front bench, if it had shown itself, which has shown itself capable of endorsing enthusiastically the very laudable amendment put down by the Labour front bench, I think number 6, could reciprocate by accepting one from its supportive backbenchers. And if so, I would strongly recommend amendment number 21 in my name.
My Lords, I stand to move amendment